have gone through the affidavits and exhibits and find that the bundle contains 839 pages, all inclusive. We find that the further statements, and in particular the intended additional evidence, including exhibits, are so detailed that the remaining time before the trial is not reasonably adequate for the respondent to file any reasonable answer. Secondly, from what has been deponed by Mr. Ongwen and Mrs. Ongera in their respective affidavits, the additional facts and evidence, in our view, tend to introduce each new matter as would change the character and nature of the petition. Section 31 of the Act provides, inter alia, quote, without limiting the generality of Article 163, sub-Article 8 of the Constitution, the rules made by the Supreme Court under that article may make provisions for D, prescribing the time within which any requirement of the rules shall be complied with, unquote. We note that the operative term in Section 31D is the word, quote, shall, unquote. This suggests that it shall be mandatory to comply with any requirements within the prescribed time. The Supreme Court Act provides for the manner in which the petition challenging the election of the president-elect shall be filed and prosecuted. As indicated earlier, under Rule 31, Sub-Rule H, the petitioner could have applied for leave to allow to file further affidavits and or additional evidence at the pretrial conference. Of course, it would be prudent for one to file such an application before the date of the pretrial conference so that it is before the court in time. However, in this case, the petitioner proceeded to file an affidavit in reply bearing on its back 6 substantial affidavits without any application for leave to do so. Landed Senior Counsel Mr. Oraro submitted to our understanding that it was the intention to ask for such leave at the pretrial conference. We understand that he would have made such request orally. The request for leave was made at the tail end of the petitioner's submissions in response to the objection. It was almost reluctantly made, if we may say so. We, however, give the benefit of the doubt to counsel on the allegations or suggestions of lack of courtesy or decorum. From what we know of the Landed Senior Counsel, is the last one to show disrespect to any court of law of whatever level. We only deem that it was a judgment or decision which was not founded on foresight or was taken due to pressure emanating from the kind of petition that was before the court and the time constraints. But the respondents and the court should not shoulder the burden of consequences of such omissions or inadvertences. As a result of the foregoing, we hereby expunge from the court records the petitioner's affidavit sworn on 22nd March 2013, together with all the annexures, which include the other affidavits. The petitioner shall bear the costs of the objection proceedings relating to the affidavits in reply. We so order.